Again, Troy Railsback, Southern States Management Group. My colleague Thomas or TJ Leach will be on the call. He had a meeting this morning that ran over. He's going to participate in the background. TJ and I have had the opportunity to grow our business. He's my lead down in Brevard County. Southern States Management Group, 1989, we got started, so we're 35 years young plus, and still trying to just continue to serve communities, promote education and knowledge in our industry with our business professionals, our vendor professionals, and more importantly, you all are our board members. We subscribe to the all ships rise in a rising tide, the tide being the education in our industry. And so we really want to make sure that we portray and convey that effort and that focus to our client base. Real quick, we are about 135 different tax IDs or HOAs or condos strong, 17, 18,000 units roughly. We're primarily in Volusia and Flagler County. We have clients in Orange County and north of us, St. John's and up in the Jacksonville area and different counties up there. And we do have a half a dozen plus, almost approaching 10 now in Brevard County. So we're real proud of that. We do have a designated office in Brevard County. Again, TJ Leach or Thomas Leach, who's been on my team for 12 years now, 13 years now, is our lead down there, lives down there. We have three people in that office on a regular basis. And if you have any questions or need to learn more about that, certainly reach out to us. And wanted to just make a big push and promotion to SCCA, again, Space Coast Communities Association. Jackie Grant and her crew invited us down into the Brevard market about 4 years ago, 5 years ago. It was pre-COVID. And after COVID, all that fun settled in. We were trying to open an office before that, but shortly thereafter, we opened an office. I've done a couple of budget basics talks, and so I really enjoy going through their education forum and talking to their associations that are part of that group. So with that said, I think Lisa is next, and she's going to give us a great presentation as well. So I'll turn it over to you, Lisa.
Well, thank you so much, and thank you for Troy for being a part of this, and Jackie for inviting the members of the Space Coast Communities Association. I know most of you are familiar with Alan Schwartzide. Unfortunately, he was detained, but here at Kaye Bender Rembaum, we all work as a team, and I'm happy to fill in his stead. So today we're going to talk about the required 1 hour legal update for condo board member certification purposes. Do want to make sure that you type any questions into the Q&A as opposed to using the chat feature. The chat feature is important for you because there will be items posted, just like the evaluation form, as Jeff mentioned, and also a link to the slides that you're going to see today. But I want to be able to see your questions, and to the extent that I can during the presentation, answer them. We should have a couple of minutes afterwards also to go through the questions as well. Remember, you can't have very personalized questions. This really is for educational purposes. So you want to talk about, or you want to ask questions related to the legal update or your responsibilities as a board member. So let me share my screen.
All right, we can see it. And folks, for those of you that came on late, remember, please press the chat button so it appears. We'll place the evaluation link there later and ask your questions, as Lisa just mentioned, in the Q&A. Lisa, back to you.
So this year, well, when I say this year, 2025, which we're still in, of course, there was one major bill that was enacted that pertains to condominium associations. UHOAs, you got off very easy this year, 2025. I can't promise the same for 2026, but from 2024, you had a lot of different changes that you're probably still absorbing and getting used to. So they gave you a break for this year. Some of the changes that they made to the condo laws and to the management statutes marry or match what happened in the HOA context in the previous year. So one of the now all CAMs are required to attend at least one meeting annually on site, so that people can see who they are. And then the owners, there must be a way for the association to ensure owners have the ability to contact their CAM, which I'm sure most of you already do. But now that the statute requires, I'm going to put this over here, the statute does require, if you have a website or some other types of music distribution, that you put the actual CAM licensee who's assigned to your account contact info on there so that they can contact their CAM when there's a need. And of course, the owners are entitled to a copy of the contract with the management company or with the CAM, but that would be part of your normal official records. Your contracts are official
And
records
Lisa,
that are subject.
I'm gonna interrupt. We're not seeing your slides anymore. We're seeing your desktop and a
Oh, oh, here.
Explorer screen.
Oh, how about that?
Not yet. There we go. That's back. Okay.
Okay. So let me just put this over here. Um, okay, good.
But
Sorry about that.
while she's
Sorry
hunting
about
that
that.
down, I will say most management companies and associations in the condominium world gravitated towards the website thing, and we have now have lots of different softwares, and some of them are better than others. But they have an owner portal, and we've had great success in posting that information and that making that stuff available. And that's one way to have an all-encompassing. You get into your owner portal and you have access to all those things.
Yeah, and when I say CAM, we're talking about community association managers. So there's two different types of licenses. There's a license for the individual community association manager. There's also a separate license for the management firm. So both maintain licenses. If you're working with an individual manager that's not part of a firm, they have their individual license. If you're working with a management firm, they have their license, but all the licensees, all the CAMs underneath them, community association managers, have their individual licenses. And in the event either one is revoked, there's a 10-year sit out period. And I'm going to talk about it a little bit later. In the event that there's a disciplinary action where the license is suspended or revoked, the association will be entitled to terminate that contract right away. CAMs also are required to have an account with the DBPR, which they did before. And now one of the changes that they added this year, 2025, is they have to list what communities that they serve. Your contracts with either your CAM or your management company will have to contain a certain disclosure. It's not necessary for you to actually modify all your contracts if you're in the mid-year, but when you do come to renewal, make sure that you have like a little addendum that includes the disclosure, and it includes the owner's rights, like the ability to list the information so that the owners have that available for them. As always, conflicts of interest were on top of mind in Tallahassee last year. We're going to see this come back when it comes to the milestone inspections and the structural integrity reserves studies. But your management contract or your individual manager must list all persons or entities with which they have a beneficial relationship. So that really refers to like any type of monetary or pecuniary type relationship. So if there's a referral fee, monetary benefit, profit sharing, they don't have to give you or disclose the actual nature of the relationship, but they do have to disclose the names of those persons or entities, because when you obtain bids for services, if if management presents a bid from one of the entities with which it has a relationship, it also has to give you a bid from a company that's a non-related company, of course, if the bid is over $2,500. So it's not necessarily a bad thing for management companies or managers to have relationships. Sometimes that will ensure the association can get better service from those service providers. But any type of service performed by a management company that's outside of the management contract would require the disclosure to be there. And of course, if you find out later that there were undisclosed conflicts, then you can go ahead and void your contract. when you have conflicts, whether it's a CAM company, whether it's a company affiliated with your management company, or whether it's a company affiliated with one of the members of the board of directors, everything needs to be disclosed on as many documents as possible. They do require it to be listed on the agenda for a meeting if you're going to approve it a contract. They also require it to be listed somewhere in the contract itself. So just be sure to comply with those technical requirements so that you don't have issues with the service providers. Now, I just talked about what they have to do on the CAM or the manager side. The board also has obligations when it's hiring a manager or a management company. The board has the obligation to verify that they have a license and that the license is in good standing. It's so easy to do this. You can type into Google DBPR license search, and you'll be able to type in the name of the company or the name of the person, and then you can see whether their license, when their license is active, when their license is due to expire, when it needs to be renewed, and you can even click to see if there's other affiliated companies or licensee problems. But as I mentioned, if the license is suspended or revoked, you as an association can immediately go ahead and terminate that contract, regardless of whether it's with an individual manager or whether it's with a management firm. This is if I have one thing to say during this our hour or so together, this is the thing that I really need to impart the most. Since COVID, and even maybe even before, but since COVID, holding meetings via video conference like this, a Zoom platform or some other type of a platform, has become the norm. And it's so much easier for people to participate. In my experience, I think it's raised the level of individual participation. It may be easier for your management and for your board members because they have their schedules where they're going to be, and they can participate from anywhere where they have computer access. The statutes now specifically allow video conference meetings via video, where there's a video element and an audio element, but there are requirements associated with them. First, some of the requirements may not make sense to you. Like for board meetings, there must be a physical location required for owners to attend in person. For the annual membership meeting, this really doesn't make sense because a quorum of the board members need to be physically present at that physical location. Now, for your annual membership meeting, the board members don't need to participate if they don't want to. For your annual membership meeting, you need a quorum of the members to participate. But I guess for transparency purposes, the legislators want the board members to be somewhere in a physical location. The most important thing is that all of these meetings need to be recorded and the recordings maintained for a year. If you have a website, the recordings are posted on your website, or a link to the recording is posted on your website, and they're official records, so they are maintained for that year. This does not apply to meetings held in other venues. So if you have a board meeting where one or two of your board members participate via audio conference, speakerphone, there's no requirement to record. But if you do have the video and the audio components where both your board members and your owners are able to participate, you have to record those meetings. Make sure that you preserve those recordings for a year and post them on your websites, if you're required to have a website. Now, website requirements have changed. If you're a condo that with 25 or more units, you're now required to have a website. It needs to be up and running by January 1. So if you haven't done it, you're kind of behind the curveball a little bit. Make sure that you work with either your management team or an outside vendor to make sure that that website's up and that you have the documents that you need posted and posted in a timely manner. Here we're talking about website and official records. When it comes to the DBPR, it's not as much of a problem in your area of the state. I'm in South Florida, where I guess it seems like all the problems ultimately stem somewhere from South Florida, whether it's Miami-Dade or Broward counties, even sometimes in Palm Beach County. But record access to records, record retention, record issues are are the number one complaint that or the most frequent and number one complaint received by the investigators over at the DBPR. Um, it's very, very important for every community association to have a records retention policy, to periodically audit their records to make sure that you have the records that you're supposed to have. If you don't have certain records, undertake reasonable diligence to obtain the records that you're missing. And if there's some records that you ultimately cannot obtain access to, well, then at least you can acknowledge that those records were not part of the records when you became a volunteer on your board or when the management came in. So your minutes must be maintained indefinitely. Now, in the past, you only maintained them. Well, originally it was 7 years, then it was 10 years, now indefinitely. So if you don't have minutes going back farther than 10 years, don't worry about it because you weren't required to keep them for that long. But now, going forward, you maintain your minutes indefinitely, and those are all, the last 12 months are required to be posted on your website to the extent that you could post more. I'm a big fan of putting as much on as you can on the website to alleviate some of the problems associated with requests for access to records or complaints about transparency and the like. The financial records were always and are always considered official records that are subject to inspection. The statute now specifically says that financial records include bank statements, ledgers, invoices, transaction receipts, deposit slips, and the like. So I know a lot of this is done electronically. The electronic records are perfectly acceptable. And for if you have an office or you have somewhere where people can, a depository, you have to have readily available copies of the governing documents, the Q&A sheet. If you don't know what a Q&A sheet is, DBPR publishes what's called a frequently asked questions and answer sheet. It's about 10 questions it's only for condominium associations that need to be answered. And once you do it once, you probably don't need to update it very often, except to the extent that, there's one section in there about how much are the assessments and are they payable monthly or quarterly, that you can update, of course, every year, depending on what your budget requires, but everything else should not really change unless you amend your governing documents. When it comes to the websites, you do have to have a website administrator. Whether you hire one, whether it's part of your management contract, whether you have an independent person that will do that, or whether it's done via the volunteers, you do have to have an administrator because the documents that are required to be posted must be posted within 30 days. And let's see if I can make this a little bit bigger. Can you see that? Is that a little bit better?
That's a little better. And folks, you'll also have the opportunity to download and save these slides after the evaluation at the end. Lisa, back to you.
Sorry about that. No worries about that. So yeah, make sure that you have those documents posted in a timely manner. Now, my experience with DBPR is if there is a complaint about a website or access to records, one of the first things they do is they ask you for a password so that they can comb through the website to see if everything is posted. Most of the time, in my experience, they will counsel you as to what is missing in the event anything is missing, but again, you want to be ahead of that. You want to do those audits on, monthly or quarterly, or at a minimum, if you're a new board member coming on, become familiar with all the documents that need to be posted and check it out yourselves. So it says in the statute that you have to post all the affidavits. I went through the statute and figured out where all these affidavits are. So the easy ones are notice of meeting notice affidavits. If you have the budget meeting notice, the annual meeting notice, anything, special assessment meeting notice, anything that requires an affidavit of notice. What I typically advise the clients to do is to attach the affidavit of notice to the meeting of notice to the minutes, and then it can save all that as one document or as 3 different documents, but in your minutes file or your minutes book. If you had a physical book, I would have it just the notice of meeting, the affidavit of notice, and then the minutes of the meeting. And if the minutes are draft, mark them draft, and when they get approved, then you'll mark them as approved minutes. So the other affidavits I have listed there's some of, well, you may not really think about on a daily basis, like confirming distribution of the financial report or acknowledging receipt of the structural integrity reserve study or the affidavits that you send out when you send out notice of late assessments. And something that we're going to talk about today, an affidavit attesting to the fact that you checked the email address that you designated for emailed ballots. We're going to talk about that in a little bit. There are criminal penalties in the Condominium Act for for fraud, actions associated with fraud in connection with elections, and a lot having to do with records access. So the criminal penalties will only apply if the violations are committed on a willfully, knowingly, and intentional basis. What I try to impart to the community association leaders is if you're doing as best a job as you can, and you're not manipulating records, you're not purposely omitting records, you're not modifying records or destroying records, then you shouldn't be worried about criminal penalties. These criminal penalties are really for egregious situations. Financial reports. The year-end financial reports deadline has been extended to 180 days. Uh, all the accountants that do the year-end financial reports are all hired at the same time and doing the work at the same time. One of the ways that you can alleviate being in that crunch period is by changing your fiscal year. Some people think that's a little bit confusing. I think it makes it easier for you. Well, it certainly makes it easier for your accountant to do your year-end financial if they're not doing the year-end financial at the same time they're in tax season, and at the same time if they're doing every other thing for the other associations. You have to furnish the year-end financial reports to the owners. In the past, you just sent them a postcard saying that it was available, and they can get a copy for free if once you got the postcard. Now, the preference is to actually send out the year-end financial report, and you can do that via email if you have permission to use email. So I'm a big advocate of using email for distribution of notices, and those financial reports can be sometimes lengthy, and it's much easier just to hit click send everybody out. The financial reports are based upon your level of income. So if you have over $500,000 of annual income, and that includes your reserve income, then you're required to prepare an audit or have an audit prepared. And there's a compilation and a review or lower levels of reports. If you're under 150,000, you're only required to have a list of all of your expenditures and receipts. So if you're at that audit level and you want to reduce it down to a review or down to a compilation, the members can vote to do that, but only 1 year at a time and only every other year. So now it's 2025. If you had the vote today, you could vote to reduce the year-end evaluation of the 2025 financial operations from an audit down to a compilation. And that would apply to the 2025 financial operations. If you had your vote in January or February, it would apply to the 2026 financial operations. Even though you're in the beginning of the year, you're basically preparing in advance for the end of the year. But if you vote this year to reduce your audit down to the compilation or down to the review, then next year you have to do an audit. And then the year after, you can vote to waive it or vote to bring it down. And then the next year, you have to do whatever is required by the statute. So you only can waive every other year. And when I say waive, that means bring it down to a lower level. You require a majority of the membership to vote in favor of that in order to get it done. There's some changes to the budget meeting requirement. So you can do your meeting virtually or or in person. And but in the past, if your budget went over 115% of the previous year, meaning more than 15% higher than the previous year, then owners had the opportunity to petition the board to consider an alternative budget. The petition the board to hold a meeting for the owners to vote on an alternative budget. That process has been modified to require the board to produce an alternative budget if you go over the 15%. not including insurance premiums, not including structural integrity reserves. So if your operations are costing more than 15% or more than 15% more than the previous year, then now the board has to prepare this alternative budget and send the alternative budget along with the notice of the adoption of the budget that proposed by the board. And it says in the statute that you have to eliminate, quote, discretionary expenditures. Well, I know you don't include discretionary expenditures. I mean, sometimes you may. Sometimes replacing the pool furniture is not absolutely necessary. Or sometimes you'll have, some associations have social expenditures in their budgets. So sometimes you may have items that are considered discretionary. Most of the time, you adopt a budget as close to the vest as possible so that you're only including the minimums. And prices go up, everything goes up. Your insurance premiums definitely go up, but they're not included in the calculation. But everything else goes up as well. So when things go up, you have to include that in your budget. The notice is still, of course, 14 days in advance, and that substitute budget is adopted if there's an affirmative vote of majority of the entire membership of the association, all voting interests. So my experience with the alternative budget in the past practice there's never been the alternative budget adopted. I have had the petitions, we had go forward with meetings, but we never had the opportunity, never once were there a majority of the entire membership voting for this alternative budget. Oops. Okay, so I want to include a little bit on the budget here. Again, some additional comments, but I do have a comment here. Must we post our board meetings as draft before they've been approved? No, there's no law that requires you to do that. And in my mind, the minutes aren't minutes until they're actually approved. Just like a proxy really isn't an operable document until the meeting for which the proxy was given is opened and the proxy hasn't been revoked or superseded by a later dated proxy. So if you don't want to post your draft minutes, you're not required to post the draft minutes. There's also a question about the video recordings. Anytime you're holding a meeting via video conference, so whether it's a board meeting, whether it's a membership meeting, even for committee meetings, it says in the statutes, those recordings are required. And that is if you have the audio and video components to your meetings. You have to have the medium, you have to have the meeting, and you have to post it to your website or post a link to the website. But if you have a meeting where people are allowed to call in, it's only an audio component, the law does not apply. So there's nothing in the law that requires you to record audio calls. And I made that example before is if you have a board meeting and some of your board members participate via speakerphone, there's no obligation to record those meetings. Let me just do this. So for the budget, the law says that the budget needs to be adopted 14 days prior to the fiscal year. In the past, many of the associations, since they didn't have their annual meetings until January and February, they held off on adopting their budget until January and February. That practice has to be discontinued. You have to go ahead and adopt your budget in December or before December if your budget is a January 1 budget. If you don't get your budget in time, the old budget rolls over, continues in effect until the new budget is adopted. For these multi-condo associations, you're required to have a budget for each condominium and a separate budget for the common shared amenities or the common areas for all condominiums. And then lately I've been getting a lot of questions about rolling over the surplus funds. Talk to your CPA as to whether or not you need a membership vote to roll over the surplus funds into the next year's budget or just roll it into operating for reserve or how you can transfer those funds. There is an IRS ruling that says that the members need to vote in order to eliminate that rollover as being considered income. But again, that's outside my wheelhouse. please talk to your CPA as to whether it's necessary. My understanding is if you fill out the form, the IRS form for your tax return, that is the HOA form. It's condo and HOA. It's just called HOA form. Then you don't need to have that membership vote to roll over the funds. Here's what I want to talk to you about, though, electronic voting versus emailed ballots. The modification this year allows people to email you their election ballot, or I guess any ballot. So if you have not implemented electronic voting is great. I'm a big advocate for it. I think it's really easy. It's so much faster. If you have a huge association, you wind up saving a lot of money. You don't have to deal with the duplication of all these materials and the mailing costs and all of that, and all of the other logistics from your labor for collecting everything and sending everything out and making sure that everything is correct. If your board has not adopted electronic voting, 25% of the members can petition the board. If you receive a petition signed by 25% of the members, the board has to call a meeting to adopt electronic voting. You still, as a board, still get to decide which platform you're going to use. And you can go through the process. But if 25% of your members want electronic voting, you're required to hold a meeting and implement electronic voting. If you haven't implemented electronic voting and you haven't received a petition for it, for the for any meetings, your members can, if they want to, send you their actual ballot via email. Now, that's not electronic voting. That's just taking their paper ballot, filling it out, and sending it to a designated email address. So for you, there's two things that you need to remember. Number one, you have to designate an email address for people to send their emailed ballots, and you have to include the required disclosures for emailed ballots. So emailed ballots have to have a space for the unit owner, and we give the members instructions on what they need to do in order for them to email their ballot and how their ballot needs to be valid. So there has to be a space to type in their unit number. There has to be a space to type their first and last name, which also functions as a signature of the unit owner. And the ballot has to contain a disclaimer in a large size font. The disclaimer says, waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote, but by transmitting the completed ballot via email, you are waiving the secrecy of your ballot, and you're doing so voluntarily. That's on your own peril. A little bit more about electronic voting if you haven't adopted it yet. What I always suggest is to try out the demos with the various vendors. Some of the vendors may work with your existing software that you use, or the software that your management company uses, and you just want to see, is it easy? Is it difficult? Is it confusing? Which one do I want to use? And then you can check and see your pricing and what have you. Then the board needs to adopt a resolution, and the resolution includes instructions on how you opt in to vote electronically, and then if you've opted in, what you need to do to opt out of voting electronically. The vendor platform has to meet this criteria that I wrote here, that it can authenticate the unit owner identity, it can authenticate the validity of the vote, has to furnish a receipt for the votes, has to store the votes for recounts or inspection purposes, and for elections, obviously you have to separate the votes from the identity of the voter, because even electronic voting, you maintain that secrecy. Once you employ electronic voting, you have to continue to employ electronic voting, but that doesn't mean that you're married to the vendor. If you wanted to go ahead and change vendors at some point for any reason, then you can go ahead and do so. You just need to adopt, it's possible that you'd have to adopt a new resolution because the procedures for opting in and opting out may have changed. So the milestone inspection updates. So the height requirement is a little bit of a change. There were always questions. It was 3 stories. There were always questions. Does that mean it has to be 3 stories of units? A lot of communities are built with 1 layer of parking, and then you have 2 layers of units on top. Those are now exempt. So it has to be 3 habitable stories in order for you to be required to undertake the milestone inspection. We talked about conflicts of interests earlier. It's another big issue that was raised with the legislators last year. If the person that you hire to do the milestone inspection, they have to disclose whether or not they or a company affiliated with them or a person affiliated with them intends to bid on the repair work. And the same thing is true for the bidder. When it comes to that time, the bidder has to disclose whether they have a relationship with the person or the entity that conducted the inspection. There's also something that's required by the local building department, and the DBPR is assembling a lot of information from these building departments, including from each building department, the number of buildings required to have milestone inspections, the number of buildings where the inspection has been completed, whether extensions have been granted, whether a phase 2 inspections were required, the number, type, and value of permit applications received to complete repairs that are identified in the inspection, a list of the buildings deemed to be unsafe or inhabitable as a result of the inspection, and of course, the license number of the building code administrator responsible for the milestone inspections in that particular municipality, county, whatever, whoever is the building authority for the property that where you're located. So the important thing is, though, the inspector has to disclose whether they are an affiliated company's intent to bid on the work that they identify, and the bidder has to do the same. Oops, let's go back. So reserves, there really wasn't a whole lot of changes to the reserves or the SERS funding. For SERS funding, that's the structural integrity reserves, you can fund them via a special assessment loan or line of credit, but in order to do so, you have to have the approval of the majority of all the voting interests. So I call that alternative funding, because when you fund reserves, the typical funding is that you fund it in the same payment and on the same periodic basis as you pay assessments for operating expenses. So if you pay your assessments monthly, the reserves are just lumped into the same bill, and you pay that one bill monthly, and the management company or whoever's handling your financial accounts has to transfer the amounts dedicated for reserves to those reserve accounts, the right reserve accounts, within 30 days. If you want to fund it through an alternative means, the special assessment, the loan, or the line of credit, you need to obtain a vote of your members. But pooling was also an issue. If you haven't already, you pooled your SERS reserves, your structural integrity reserves. Now you don't need a vote to put those funds into reserve. So you still have money in a roof reserve and in a seawall reserve or in a concrete waterproofing type reserve. Those line items can now be transported into the pool, or that the money in those line items can now be transported into the pool, but you have to have a separate pool for your structural integrity reserves. You can have another pool for your non-structural integrity or non-SERS reserves. There's nothing in the statute that allows the board to do that on its own. So the members would still need to vote to move any straight line reserves into a pool for the non-SERS. Um, and I don't know why this was in the statute, but you can get a loan or a line of credit to fund the capital expenditures. You can also pause your funding of your structural integrity reserves. Well, if your building is due inhabitable to a natural disaster, thank you. You don't have a place to live. Thank goodness you don't have to fund the reserves during that period of time. But you can do 2 years if your building milestone report is done prior to 12/31/28 to focus on the repairs identified in the milestone report. So for milestone report today, 2025, and it says you need to have all this concrete restoration, new roof, painting, waterproofing, that work is going to take 18 months. Now you need to pay for that work. So during that time, you can pause the SERS funding during that 18-month period so that all your money can be dedicated to pay for that work. And then once that project is complete, of course, your SERS is going to be updated because all your timelines are going to be extended, and then you have to start funding your SERS. And that's noting about that. If you have extra money, you want to put it into your reserves, or you want to collect more reserves than your reserve provider recommended, that's great. It's wonderful. There's definitely nothing wrong with that. But you do need to go back to your reserve provider and have them recalculate your recommended funding or your baseline funding. I think they have that on the next slide. So, because once you add money or you add more money or you're funding or you're funding a little bit differently, you're changing what's in there, and then you're changing all the numbers. So they have to just change the schedules, and they do updates. They call them non-site inspection updates, I believe. Talked about baseline funding. Everyone talks about full funding. What means full funding? What does full funding mean? Full funding now they called it baseline funding, and what that means is that the number never goes below zero. So it's full funding, baseline funding, compliant funding, statutory funding, whatever you want to call that word, because there are terms of art that are used in the reserve industry, primarily the CII reserve professionals, that you have to have funding that never goes below zero. And all of your non-SERS components need to be separately identified. There were complaints received by some legislators last year that associations increased their costs dramatically and claiming, well, we have to fund SERS, we have to fund SERS. And when there was more detailed evaluation of what was transpiring there, they were including all kinds of building upgrades in connection with the SERS, which may be really important and really pragmatic to do. I mean, if you're going to be upgrading a certain electrical items, you may want to change the light fixtures at the same time. But changing the light fixtures is not part of the SERS. It's the electrical that's part of the SERS. So you have to have that separately identified. And then, of course, this says you get the updated study. If your reserve amounts differ from what your funding schedule says, go back to your reserve provider and 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 um and have them recalculate what your recommended funding is. Again, with the conflicts, your reserve provider must disclose whether they or an affiliate intend to bid on the work that will be performed. The companies that solely conduct reserve studies don't typically have affiliated companies or entities that actually do the contracting work. But of course, engineering firms may have a construction component to their firms. And now there are the full service type firms that are creeping up, where you have the architect, engineer, contractor element, and reserve professional element all in one company. So they just need to disclose whether or not they intend to bid on it. And then, of course, any bidders need to disclose if they have a relationship with either the reserve provider or the milestone inspector. Investment of reserve funds. I think you'll see this coming up. I don't know if it's going to come up this year, but I think you're going to see some really detailed investment protocols in the future. They're still working through them because it's kind of complicated how you tell people how to invest. But the investment options are expanded. Still, take a look at your bylaws or your governing documents. A lot of times, your governing documents will have limitations. It has to be a national banking organization cited in Broward County or cited in Osceola County or what have you. So take a look at what your own limitations are, but the law does allow you to use community savings banks, commercial banks, credit union, savings and loans, community types of financial institutions. Uh, the board has a fiduciary duty to use its best efforts to make prudent investment decisions that carefully consider risk and return in an effort to maximize returns on invested funds. There's no owner vote required for whoever you designate to monitor investments, to recommend to the board. The board will just authorize the funds to be put in various certificate of deposits, or you may be working with a broker that has, that has fiduciary capabilities. I think we're going to see this going. I think we're going to see this in the future, that there's going to be a little bit more control um, over the reserve funds. So there's a question here. If you use a line of credit to fund your reserves, must the loan actually be active or just available when needed? So if you're using a line of credit really typically means that that you have a line that's available to you. So that doesn't mean that you have to actually borrow the money, put the money into your reserve accounts. The line of credit is exactly that, a line of credit. The state does not have an opinion on whether or not you take the money, physically move it into accounts, and then start payback on your loan, or whether you have that line of credit. Now, I am loath to recommend borrowing to fund your reserves. So I think it's far more prudent for the association to borrow if it needs to borrow to actually perform work. And then you're in a repayment period for the work that's been performed, then to be paying interest, well, to a financial institution for the purposes of funding your reserve. So the state doesn't really care. I do not recommend that, and it's just another way to kick the can down the road, because if you have this LLC to fund the reserves, and an issue comes up, first of all, LLCs, it depends on how long they are. Typically, they're 1 year and they're renewable for another year. Some banks are now offering up to 3 years, but you actually have to go through that process, and there's a cost associated with the LLC itself. Secondly, when that item comes up, you will need to draw the money out. So then you'll start paying the interest on the money that you've borrowed. In my mind, it would just be far better for you to borrow the money, get the work done, recalculate your reserves so that you're on a longer payout period. Oh, sorry. Oops. Um, Treasury bills count as suitable investment vehicles. I have clients that do have money in treasury bills. I am not competent to give you investment advice. So for that, really need to rely on somebody who is a financial planner. I mean, there are different types of certifications for financial planners that you trust, that's going to give you a prudent investment plan. And yes, I am aware of some associations that do have alternative types of investments. Uh, Um, okay, let's move on. Online account registration and resources. This we can actually just blow right through because you should have already done it. So if you haven't done it, please send an email to this CTMHE education. So condominiums, timeshares, mobile homes, education at myfloridalicense.com, and figure out what it is that you haven't done, because you need to do it. You're already past the point of no return. This slide right here pertains to a bill that was also adopted, or a law that was also adopted in 2025. It's not a required part of your board continuing education for certification purposes. I thought it was important. For the association's purposes, the association is not a seller of the real estate. So the association is not the party that's obligated to provide these disclosures, but flood disclosures are now required in any type of a real estate transaction, whether it's a sale or a lease. Um, and this is really important. The west coast of Florida has just been hammered with major flood flows. I mean, you and the central part of the state were also hammered with major flood claims. And individually, if you have flood insurance claims and the repairs that were identified to be performed as with the flood insurance funds, if they have not been performed and there's another flood loss later, those components will not be compensated. You won't be compensated for those components. So if there's a flood loss and in for these for individuals, if you have a flood loss and you make a claim and you've performed the repairs, keep those documents because you want to going to give those documents to your buyers when you sell so that they have evidence that you made the repairs that with the funds from the flood insurance and that won't jeopardize their ability to file a claim going forward. Um, yeah, let me see. And My Safe Condominium Pilot Program, again, that ship has sailed. All of the funds that were dedicated to, I think it was $30 million this year that were dedicated to the plan were absorbed like immediately. In order to go through the plan, you have to apply for the inspection. The board can approve applying for the inspection, but when it comes time to apply for the grant, you're going to need a membership vote that's been reduced from 100%, which of course is untenable, down to a 75% owner approval. And they haven't really changed the basis on which they fund, but but again, you have to be on top of it and sign. It's almost like getting the first place ticket when you're on your to board the airplane. Yeah, if you're not there, like white on rice, you're going to be in boarding class C, which is I'm always there within 1 minute and I'm always like boarding class C. So I don't know how they have the magic trick, but they're able to do it. So these are some additional resources. Jeff, if you received this program electronically, these should be active links. I tried them myself and they did work. If they're not, just go to the DBPR online portal and they can help you navigate all of the resources that we have from the DBPR. So we went through all of the items that are required within a quick period of time. Troy, are there any issues that you've experienced this year with respect to the recording of the video meetings or otherwise that have been problematic or remarkable in any way?
Yeah, so I'll touch on a couple of the topics that you that we're seeing some questions and level of interest and positioning and thought process changes or confirmation. So the video conferencing or remote meeting setting because of the the ability to record and have meetings archived and those recordings I've seen law firms position in two distinct manners, meaning one, having transparency and access to the board and the ability for people to participate remotely is a great benefit, leverage technology. And so great things operate. The association has allowed or has the ability to operate and give people the ability to participate, even if they're in a listen only mode based on their board policy and on how they interact with remote residents and just giving them the ability to not necessarily disrupt the meeting, but also interact during motions and that type of thing. So I think a strict policy and a thought process going through that is very important. So everyone feels that they're engaged, no one feels they're disenfranchised and they have their opportunity. And also no one feels interrupted because noise in the background, technology issues, stuff like that. Another consideration and another thought process related to having the meetings recorded and having that recording always available from a discovery standpoint when there's a challenge, when there's a something that an insurance claim or just something happens when you are able to, as part of your policy, you archive all of those recordings. There's things that have been said, whether it's in context or taken out of context, that can, be problematic. And I'm not going to dance around it, can be used against the association. And I think you have to think through those things when you say, hey, I want to give access to everyone. I want to record it. But remember that every word that's said is part of the association record. And you just have to, conduct yourself accordingly and understand I guess the term would be exposure with that. So you all can certainly add to that comment.
Yeah, I'll tell you where that really became problematic, and this is way in the past for the hurricane claims. So what we always recommend as lawyers, we say it's minutes, not hours, just facts, Jack type of thing for your minutes. So you want to have your, who has attended, the time opened, the notice of the meeting, proof of notice. You also want to have your motions, and you want to have how all the directors or the owners voted on those motions. You
Mhm.
want to stay away from having long narratives talking about the discussions. Here's how it became problematic for some of the clients is that if you had people coming to the board complaining about windows leaking or other types of leaks or other types of problems for whether it was months, possibly years, those documents became available to the insurance companies, and the insurance companies utilized them to say, hey, listen, some of this stuff was pre-existing.
Yeah.
We don't think that this is hurricane damage or storm damage. We think that some of this was pre-existing, and we're not going to pay you for it. So
Yeah.
that's why we say minutes, not hours. That's why in the past we never well, as attorneys, we never recommended recording these meetings. But yes, Troy, you're definitely
Yeah,
right. You have to
and
maintain
I
a level of
won't.
decorum too on these
Yeah,
meetings.
and I won't
And
belabor it, but I do want to highlight something you said about the minutes. We've always been an advocate for years that it is minutes, not hours, and our minute format would be, and it's basically. I'll backtrack in a second, but you want to capture the flow of the meeting. So you take your agenda and all your agenda items, and there should be something related to each of those components. There was board discussion, maybe there was significant board discussion, and not Mr. or Mrs. said this, and then that person reacted and said that. And so, you want to capture that there wasn't just a kind of a, hey, yeah, that sounds a great idea. Motion second, boom, it's over with. There was lengthy discussion. So you can, as far as developing your minutes, we thoughtfully and carefully advise boards to use that as their expectation when they're reviewing minutes to approve them, and then also have someone consistently preparing or reviewing those minutes. So I do it for my board, and I have a whole team of people that help me. I have 1,900 homes that I manage in one association, and we have lots of things that get discussed, but I ultimately will create the discussion narrative and some of the add-ins and then go to the motions. And so making sure that's really consistent is very helpful. And again, as you indicated, to just make sure that you have a steadfast policy and best practices. This is a boring agenda item, but it should be discussed at a meeting. And we make sure that our board say, hey, there's a change. And this was again 10 years ago. There's a change in how we're going to prepare our minutes. We're moving away from a narrative to more of a outline format, and we're capturing the key components, the key discussion items, and we're going to use, and that's basically what the expectation is when you get these draft minutes and the board all agrees and they're good with it. And then when you do have owners and property owners and people who are challenging, well, I wasn't there. I want to know who said what. And, basically from a consistent standpoint, we say the meetings are open. We schedule meetings a year in advance. And so when the meeting is. And as we discuss stuff, there's not a lot of things that just get discussed at one meeting. In most instances, you've talked about it once or twice before you're taking action on it. You bring it up, get more information, then it's basically, all right, we're going to take action on this, or we're going to consider taking action on this. So you got 30, 60 days a lot of times where this is something that you can say, hey, I have a business meeting, or I may or may not go out of town. I want to go to this meeting, or I want to participate via Zoom, or whatever. And so you have the opportunity to literally hear the dialogue, and then that should hopefully accommodate anyone who just wants to hear it rather than just see the action. So, and then the second topic was the whole alternate budget, right? And so, there was the obligation on the group who petitioned the board to have an alternate budget. And you really have to, as a board, understand that if the budget this goes through this petition process, or this process to have an alternate budget, the board needs to take action quickly, because you have to go back and start whittling down what's in that budget and figuring out, what the alternative is, and then be able to present it to them within that time frame. So we really focused on that, as we go through the kind of the our education series. And I'd be remiss, as we have a education series that we're putting on in Brevard County for HOAs only. And so we're doing heavy duty specific stuff, meeting decorum, how to get through a successful meeting, budget basics, and then ARC and compliance is a really hot topic. And that could be a whole day worth of information for HOA. So we're doing something around that. But I would advise any board to really don't pull like kind of something out of the air when it happens and say, this is what we're going to do, right? You're going to have to react to circumstances, things that happen with the association, things that happen with your building, things that happen at a meeting, where a meeting gets very disruptive, whether it's technology or something's happening and individuals aren't participating in a manner that is constructive and productive, and it disrupts the meeting. At the next board meeting, that should be a topic, and you should address that, and you should have either a policy or some type of action plan, whatever it is, whether it's a disruptive owner or just how you're going to address audience comments. I see a lot of boards do audience comments at the beginning of the meeting on non-agenda items. We do that, that's the best practice that I put in our board meetings. We had owners that were really frustrated with, hey, I don't want to sit through 2 hours of a meeting just because I want to make a comment. Great. We put it at the beginning. You fill out a comment card on what it's going to be, so we know. And if it's an agenda item, we say, great, we have an agenda item on that, so we're going to save that for down on new business or unfinished business, and anything else that you want to just address the board and make a comment. And if they have to leave or they want to leave right after that, they can. And our policies, we don't have to react and give you an answer today. We're just taking your audience comment in an utter advisement, and we would potentially address it at a future board meeting. So those are the
That,
things that we see as the legislature change, as the opportunities for exposure or not exposure. You as a board need to just contemplate those things and come up with how you're going to address it.
that's all very, very good advice. And yes, I do see people that are frustrated. They're frustrated particularly when all comments are held to the end and after the board already takes action. And I can understand that frustration, because if you want to speak to a specific agenda item, you
Mhm.
don't want to speak to it after it's already a fait accompli. You want to have your statement, whether or not it's taken into consideration,
Yeah.
on record in connection with the board action on that item. And I think it's nice to have a period where you can take off top or off agenda questions. With condo associations now, at least 4 times a year, once a quarter, you
Mhm.
have to have the off agenda opportunity to ask questions about the budget, any construction projects,
Mhm.
and all that other good, or financial operations and all that other stuff. So if you do that
And as a
every meeting.
practice, to further, have the concept in each of the board members' mind, as a practice, when the boards that I'm involved with, when we're taking down contentious stuff or stuff that has a lot of participation, we will read a statement that basically lays the format out. And if we have the same board, same audience participation that we normally do, that have heard the comments for, they know how it's going to go down. But if it's newer faces, and again, if you have something on the agenda that we know that it's going to have lots of input, we would tell them we have audience input at the beginning of the meeting. That's for any non-agenda item, and as a property owner, we want to hear from you. Okay, if you have a interest in an agenda item, what the board is going to do is that we're going to introduce the agenda item. We're going to talk a little bit about it. There probably will be an initial action taken by the board, which is a motion and a second, and that really opens up the dialogue. Please understand that that motion can be rescinded, changed, amended along the way. After the board has their discussion, because technically they need to have a motion and a second before they get into deep, deep, deep discussion, we're going to turn, and they're done, we're going to turn to the audience and we're going to take all of your input. We're going to go one by one, wait your turn. If you have some type of topic or some specific thing you want to address, please do so. We have a kind of a 3-minute rule, but we want to hear what you have to say. We're going to try to stay with that. And as another audience member following previous comments, if you have the very exact same input or comment, please say I ditto what she or he said. And I want to reiterate, it's really important to me that you guys consider this. And here's my other concern. And then we will get through everyone. And then the board will have an opportunity to take all of that input. And if they want to change their motion or they want to change their direction on that topic, that's when they will do that. So, and we
So,
read that
well,
to everyone, and we generally have, and as a board, 10 years ago, we decided that this is how we're going to address this stuff, and the statute has supported, these types of things along the way. And so our board, when an owner says, I did have an opportunity, we can show them at every meeting, this is how we do it. And consistent, equitable, non-selective, and making sure no one's disenfranchised. That's just those should be your goals in the meeting.
So I want to thank everybody for participating today. I want to thank Southern States Management. I want to thank the Space Coast Communities Association. I know that you're very active up there with what's happening in Tallahassee and with what's happening with community associations just generally. And you're the example of why community associations work. I mean, taking your time out of your days to become educated, to comply with the requirements of the statute. That's all that everyone can ask for, and we do appreciate it.